How's everybody doing? There sure is a lot of patriots in Humphrey County, you know what I mean? Got them all up here. We don't let everybody know they're here. You know how it is. Might be a strike. Could be a drone strike any second, you know what I mean? It's going on. It's going on. No, it ain't funny, really, actually. That's pretty serious. But glad you guys made it out on blizzard night. It, about as bad as it gets here. I come out of Virginia, talk to the kids today, they got a foot, and talk about going somewhere and messing around for a while. So it is what it is. But appreciate you guys coming out. We got a full schedule tonight. We're going to try to keep you in your seats. I hope you don't walk out on us. And we have T-shirts. We run this dog and pony show with donations, and we appreciate you guys for doing what you do. We never have any money, but we never need any money. Every time we're short, it comes in, and we take that as a sign we're doing things right. If it starts to come up short every month, then we're going to have to take a real good look at what we're doing, because we might have dropped the ball somewhere. But we'll get started. Mr. Richard Chernock is going to lead us in prayer, and this guy knows how to do this, I'm telling you.
I don't know about that, but we have a wonderful God. We got it. I'll tell you what, he answers some marvelous prayers, and so we really, he just blessed us so much. Well, let's pray. Lord, we come to you to praise you tonight. You have blessed us in so many ways. You blessed us with some wonderful, God-fearing forefathers who, through a great deal of effort, came up with a Constitution and a Declaration of Independence that survives till today. And Lord, we just thank you for that. We thank you for the blessings you've given us. We thank you for the freedom that we still share. And we just thank you for just the many blessings you give us. You know, there's so many things, Lord, that we don't even think about that are blessings that we have. And we just thank you and we praise you. Lord, we need your wisdom and your direction in everything that we do. We need to know what to do and how to do it. We need your wisdom and direction to do that. And we need your holy boldness to do anything that we need to do. And we just praise you. Lord, we lift up those people who are governing our country. We ask that you would touch them, that you would guide them, that you would direct them to do the best for our country. We ask that you would direct them that they can get together and really come up with the correct answers. And we thank you for this. Lord, there are so many people that would put down Christianity and would put down our Constitution. We ask that you would touch those individuals and either change them or remove them. Lord, again, we praise you. We praise you that we have an organization that is making an effort to bring our country back to what it should be, to where we can be a blessing to the entire world. And we thank you for that, Lord. Lord, we just praise you. We ask that tonight you will be very present in our meeting, that you would make this worthwhile for each one of us. So now we just thank you and praise you. And all these things we ask in Jesus' name. And all God's people said, amen.
He always does good at that. This time, Mr. Ernie Sullivan will lead us in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thanks a lot, brother. At this time, we'll have a patriotic song by Miss Julie Decker, and this is going to be a good one, guys.
Oh, beautiful for space. skies for amber waves of grain, for purple mountain majesties above the fruited plain. America, America, God shed his grace on thee, and crown thy good with brotherhood from sea to shining sea. Oh, beautiful for pilgrim feet that stern impassioned stress, a thoroughfare for freedom speak throughout the wilderness. America, America, God mend thine every flaw, confirm thy soul with self-control, thy liberty in law. Oh, beautiful for patriot dream that sleeps beyond the years, thy alabaster cities gleam undimmed by human tear. America, America, God shed his grace on thee, and crown thy good with brotherhood from sea to shining sea.
Julie sings at the church. A lot of times she's with the kids. So she does like a little special number every now and then. I remember sitting there, I was kind of nodding out a little bit. It wasn't because the pastor here. It was just because I'm like 4 o'clock in the morning trapping. And she lit up and I went, wow, where's that coming from? You know what I mean? It's like, it's impressive. We're blessed to have those. Think about the people that have done that song here. You think about some of these people. I didn't know there was that many good singers in the world, much less in a county, but we're blessed. All right, this time Mr. Johnson's going to give us a little blow-by-blow on a little history lesson, and he'll take us to where we should be, and a little later we'll do a thing on where we are now.
In order to understand what has happened a week ago at the Senate, you've got to understand the principle of nullification. And nullification is almost a scary thing to some people, but you've got to understand more about our Constitution. Now, can we, the people, nullify laws? No. No, that's anarchy. But we can demand our legislators in Nashville that this state will be protected by this principle of nullification. Now, let me explain to you a little bit. I've given you my outline because I got 30 minutes, so I got to run through a lot of stuff in this. But I believe if you'll listen closely, I think you'll catch enough of it that we the people can understand more about our Constitution. Where did our Constitution come from? We have to go back into American history and understand there were 13 colonies. They all had separate governments. They had separate monetary systems. They had separate judicial systems, separate legislatures. One colony would charge another colony a tariff for goods going across state lines. They were literally like separate countries, which is what they were. All right? These 13 colonies decided that they wanted to declare their independence from England. They wanted to declare their independence. And when they did that, they united They united and came together and became the United, small u, States, capital S. The United States. These states formed together. Now, they had to have something that would help them work together to where you could have settled disputes. So they formed the Articles of Confederation. The Articles of Confederation were a set of rules that the country operated under. And it made it through the Revolutionary War. But it's very weak. It was weak, and then by the time the war was over, then they realized they needed something stronger. See, in the Articles of Confederation, there was no executive. There was no executive branch to execute the laws. There was no president. There was no judicial branch. The individual states still had their own court system. And the Congress didn't control the military. The individual states were issuing their own currency. You know, the state of Massachusetts, you had currency there, and some of the currency was difficult. The inflation was rampant. There was, in 1786, there was a rebellion in Massachusetts by a Revolutionary War general, Mr. Shea, and it just about brought the whole thing down. And they finally got enough militia there to control it, but they realized they had to have something bigger than the Articles of Confederation. So they went back into a constitutional convention, and now these are patriots who had been under British tyranny. They knew what it was for a king to tell you had to do things you didn't want to do. And they didn't want to go into that. And so they formed together, and the wisdom from God was there, without a doubt, but they formed a United States Constitution. And the Constitution became this box that kept this president in check and kept this government. The federal government became this giant entity that was over these individual states. You have to catch that whole idea, or it won't make sense. Some of the states would not even ratify the Constitution until a Bill of Rights was placed. So 9 states did ratify it, and then the U.S. Congress came into being, and then they wrote the Bill of Rights, and then all 13 colonies went ahead and accepted it. But the Bill of Rights were to guarantee the people that they would have this protection against an overreaching government. These rights were given to them. Now, you'll see on the back sheet there, and I'm sorry, on the one side it got off just a little bit. There's a couple of letters missing there on the far right-hand side, but I think you can work through it. I took my Constitution apart, blew it up, and took out some of the parts that I wanted to share with you tonight, and so that's, you can work with that. But you can see that I've entered just a couple of the amendments, Amendment 2, Amendment 9, Amendment 10. Amendment 2 is the one in question right now, and you see it says there in the middle of the page, a well-regulated militia being necessary to the security of a free state. The militia was to protect the states. The right of the people to keep and bear arms shall not be infringed. You will not infringe. You will not put anything against it. The people to have and bear arms is completely given to us. It's a right, but then the 9th Amendment tells us those rights didn't come from the Constitution. The enumeration in the Constitution, Amendment 9, of certain rights shall not be construed to deny or disparage others retained by the people. The Constitution doesn't give us the rights. God gave us the rights. They're God-given rights. Life, liberty, and pursuit of happiness, and these things are required. If I have to protect my life, then I need the weaponry to protect my life. The 10th Amendment declares the states and the people have all the rights not spoken in the Constitution. If the Constitution doesn't say the Congress can do this, then they can't, and the people and the states have that. The 10th Amendment says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. That tells us that the Constitution limits very closely what the federal government can do. It's a box that contains this behemoth that he could never come out. Well, what do we do if the United States government steps out of the box? You go to the Supreme Court, they're part of the government. Do you go to the president? He's a part of the government. Do you go to Congress? They're a part of the government. I mean, what do we do if the Congress and the President of the United States, all of them, they've all stepped out of the box? So what do we, the people, do? And that's where nullification comes in. All right? Nullification is the recourse of the people through their state legislatures. Let me illustrate it this way, and I think it might help you to see. You've got to see this picture of what it is, okay? When the states put together the Articles of Confederation, that's what that says, the Articles of Confederation, they created a beast. Where's my beast? Come here. Beast. All right? This is my representative of a beast. She's not a beast. This is my daughter, all right? Now, no, that's a representative. Now, put the hat on, and she represents Uncle Sam, all right? Now, the Articles of Confederation were this box. Now, they didn't even have a president. They didn't have any court. There was just the Congress, the Continental Congress. By the way, one of the first acts of the Congress was to order Bibles for all the soldiers. One of the first acts of Congress, all right? And that's just a little side bit there. But this turned out to be too weak. And so in the Continental Congress, we decided the Articles of Confederation wouldn't work. So we put together a Constitution. Now the Constitution, then the Congress came back in session, and they disbanded and then brought in a behemoth called the federal government. But wait a minute. I knew he's a lot bigger than me. I represent the states. He's a lot bigger than me. No, get in that box. Get in that box. That box, that Constitution is the box that contains this beast that we created. You've got to see this picture. People don't understand it, and so sometimes all the time lately, but sometimes he starts coming out of there, and so what do we have? We have a paddle called nullification. Nullification is contained by the states to say, get back. That's the purpose of nullification. Now, we're making somewhat of a joke, but you got to see this picture. This is the only recourse we have. He's bigger than I am. He's got a lot more weaponry. Good night. Why has he bought 2 billion rounds of ammunition in the last year? 336,000 last week, or yesterday. And then when we tried to ask him, what are you doing? Oh, we didn't do that. We haven't done this. We're not going to tell you. We need it for training. Why do you train with hollow point ammunition that costs more than steel jacketed? Well, wait, see, this is the only he's already come out. He's already out here. And we're sitting here saying, what are we going to do? What are we going to do? The only thing we can do, only thing the states can do is use the paddle of nullification to stop him and put him back in that cage and say, now you stay there. We gave you that power, and that's all the power you have. Now you stay there. The Constitution, Thomas Jefferson called the Constitution the stick with which to beat back an overbearing government. Thomas Jefferson. They knew we'd need it. Okay, you can go. But literally, we have to see this. We have to see this, and our state legislators don't see it. We have to require them, demand them to understand this principle. Now, let me show you some of these objections that they'll come up with, and you'll see it. You'll see the chairman of the State Senate Judicial Committee. That's the committee that all the gun bills go through. May Beavers was there, but because allegedly she's not a team player, our alleged conservative Lieutenant Governor Ron Ramsey booted her out of the chairmanship and put one of his yes men in there named Brian Kelsey. And you'll see Brian Kelsey. Now, he's been to law school, so he knows this. Look, we've got a Constitution, so we know what the Constitution says. And we, the people, have to decide we're going to put that government back in the box of the Constitution. Let me show you the objections. First of all, the first one they always bring out is the Supremacy Clause. Oh, we're the supreme, the Supremacy Clause. Well, look at your page that has the Constitution, where it says Article 6. Now, like I say, this is way out of order. I just clipped some little pieces in there, and you see I've got it highlighted. The middle paragraph there of Article 6, it says supreme law of the land. That is the Supremacy Clause. But wait a minute. Let's understand it. First of the paragraph says, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. The key phrase to understand this is in pursuance thereof. If you're pursuing someone, you're right behind them. You're going right after them. The only laws that are supreme are the laws that are pursuing the Constitution, that are in pursuant of the Constitution. If the laws are following the Constitution closely, then yes, they are supreme. If the laws do not follow the Constitution, then the states have the right, yea, the responsibility to nullify them. They have the responsibility to, because you see, it's not only just our freedom. Well, we can trust them, they're okay. What about for our children and our grandchildren? Every generation must hold to this freedom, all right? The Supremacy Clause is only applicable to laws that are in pursuit of the Constitution. Second one they use is General Welfare Clause. That one's been used, well, for the general welfare, but now wait a minute, let's go over there to Article 1. Now, Article 1, Section 8 gives you the 16 duties, or it depends on how you count them. There might be 20-some. It just depends on how you count them. But there's 16 twos. They have the power. You see up there at the beginning, the Congress shall have power, and then to lay and collect. The next paragraph, to borrow money. Next paragraph, to regulate commerce. Next paragraph, to establish a uniform rule of naturalization. Those are their duties. You understand Section 8, Article 1, and you'll know everything Congress is allowed to do. Nothing outside of Section 8 is allowed to be done by our Congress. If you cannot read Department of Education in the Section 8. You will not find Department of Energy. You will not find the EPA. You will not find, that's where all these unconstitutional acts of Congress come. They've overstepped their bounds, and we're going broke paying for them. All right, it's time to use nullification and put them back in the box. General welfare, what that actually means, look at it. They're spelling out all of these duties, so general welfare doesn't mean they can do anything they want. General welfare has the idea that no state is to have preference. It's to be for the general, whatever they do, whatever the United States government does, is done equally throughout all the states. It is to help all of the states. They can't favor one state over another. That's what the clause means, but it's been misinterpreted to say they can do whatever they want. Why would they in fact, you read your Federalist Papers, why would they spell out the duties if they could do anything they want? They've given them their duties right here, and nothing outside of these duties right here are to be accomplished by our Congress. Regulate commerce. This is the Commerce Clause. You're going to hear that one. And that's the one that used the Commerce Clause back in the 1930s to tell the farmer he couldn't grow wheat to feed his own animals. See, this is nonsense. Look at this. Look at this. It says to regulate commerce with foreign nations and among the several states. Now, how does the Congress regulate commerce with foreign nations? We decide if we can send some cattle over to Japan. If we don't think they should have them, then we don't. We can shut that off. The United States government can say no cows are to be shipped over to Japan. They can regulate the commerce between the United States and Japan, foreign nation. But now wait a minute, does the United States government have any say-so if they ship the cows over to Japan? Do we have any say-so over what they do with those cows in Japan? No. No. You look at that sentence again, it says to regulate commerce with foreign nations and among the several states. We're to regulate the commerce among the states exactly the same way we regulate between the nations. They can decide whether Remington Arms ships guns from New York to Tennessee. They can decide. They can decide, oh, you can't cross the border with those guns. That's fine. But if it is shipped to Tennessee, it's up to the state of Tennessee to decide what happens to those guns. It's the government has no say-so once the product enters into this state. Read it. You read it. To regulate commerce with foreign nations and among the several states. It's to be done exactly the same way. I checked this with, I've not heard anybody use this idea, and I checked it with several people who understand the Constitution better than I, and they say that's exactly right. That's exactly right. The way it's written, the way it's given, to regulate commerce with foreign nations and among the several states, they have the duty to regulate the same way with foreign nations as they do with our several states. Okay, so that one's out. If they try to tell us what to do, what do? Nullification. That is our only recourse as a state to nullify. Necessary and proper. That's down there toward the bottom of Section 8. All that is saying they can make any law that they need to do in order to enact these other duties. There's one of them here in the middle, to establish post offices and postal roads. All right, that's their duty. So if they need to make some laws that they have to be a certain setup, then they can. They can make the laws that are necessary to set up the post offices, to make the postal roads, to make all laws which shall be necessary and proper for the carrying into execution the foregoing powers. Not to do anything they want, to carry out the duty given to them by our government that limited the federal to the Constitution. Case law precedent, you'll hear that one a whole lot. Well, case law says this or this or this, and I've got this. It's not my duty to accept the wrong actions of others. See, every generation has to fight for their own freedom. If others have made mistakes, I need to go back to the original doc. You do any building, your foundation is here, it's set. Now, if your first floor is maybe a 1/4 inch off, and the second floor is maybe 1/2 inch off, and then the third floor gets, an inch off, you start going up there very tall, and you got a mess. You don't go by what they did last time. You drop a plumb line and you go down to the foundation and see what the foundation says. You line it up with the foundation. And that's what we need to do. We need to go back and we need to elect people in Nashville that understand this principle. And when these people come up here, when these people that are running for office in Nashville, whether it be state senator or state representative, we need to ask them what they feel about nullification. If they don't have the backbone to stand up and say no to the federal government, then we don't want them. We want to elect people that have the backbone to say no to this behemoth that we created. Who created the federal government? We the people did. Who can control it? We the people can, with nullification. Some of them will say the Civil War settled the matter. Well, hang on, hang on. You tell that to any playground bully. All that a battle decides is who's the biggest and strongest one. So you and I are out on the playground, and you say the sky's blue, and I say the sky's brown, and I got a big brick, and I hit you over the head and knock you out. Does that make the sky brown? No, no. Just because someone is bigger and more powerful than someone else doesn't mean what they say is right. If the base that they establish, the Constitution that they establish says it's right, it's right. If the Constitution says it's wrong, it's wrong. And when the federal government steps out of the box, it's our duty to elect legislators that will use nullification to put it back in the box. Okay, where did it come from in history? All right, we see nullification began 1798. The President John Adams established, they were having a war with France, somewhat in France, because we weren't paying our loan back to France because it was a different government in France, long story there. They were coming after us and taking some more ships. And there were people making bad remarks about the Congress and the President, so President John Adams made a rule, the Alien Sedition Act, there were several parts of it, that if you speak against the President or the Congress, you can go to jail. And they started putting people in jail. Well, in 1798, Thomas Jefferson wrote a resolution for the state of Kentucky, the people of the state of Kentucky, and James Madison wrote a resolution for the people of the state of Virginia saying, no, that law is nullified. The Alien Sedition Act is not in effect, and therefore, if you speak out against the government, if they try to put you in jail, then that law is no longer valid. That's where it started. And James Madison was what many people call the writer of the Constitution. He was base ideas to it. And Thomas Jefferson was the man who penned the Declaration. So we're getting pretty close to our founders, and they disagreed with what the government did in 1798. In 1809, the state of Connecticut nullified the government put an embargo to stop the produce, the goods coming out of Connecticut, and the Connecticut legislature brought out the tool of nullification, quoting much of what Jefferson and Madison said, and said, no, we're not there. It's not going to happen. The same state, Connecticut, there did it again. I've got to get my notes here somewhere. There we go. The conscription law, the draft law, they put them in there. Virginia did it for the federal funded internal improvements. Now, the one most history books quote is the South Carolina in 1832, 1833, because they were probably a little over-aggressive with it. But that's the one they all quote. But they don't use the one in 1859 under the Fugitive Slave Act, which said that if you harbored a slave or helped him escape, then you could be incarcerated. Joshua Glover in 1854 left his master, he was a slave in St. Louis, Missouri, walked all the way from St. Louis, Missouri up to Wisconsin. He lived there for a couple of years. He was found out. The federal marshals come in and captured him. Well, Samuel Booth was a gentleman that he was a newspaper writer, very much anti-slavery, and he stirred the people up, even going around on horseback from intersection to intersection, telling the people, a man's liberty's at stake, a man's liberty's at stake. And he formed a crowd there around the central square, around the jail, and they had several speeches. Sherman Booth brought some of them. And they decided, we need to liberate Joshua Glover. We don't have the keys. And the guy brought out a big 2x4, and he says, here's a key. And they broke the door down to the jail, took Joshua Glover out. He escaped and went to Canada, where he lived and had a family. But the federals said, oh, you're a bad guy, Sherman Booth. You helped that man escape. And so they put him in jail. The Wisconsin Supreme Court said, no, we're going to protect our citizens. He ordered a writ of habeas corpus. He ordered a trial by jury, and they said, no, there's no crime committed. Go on. Federal marshals come in again and said, we want you. The United States Supreme Court said, we want the information. And the Wisconsin legislature said, the fugitive slave law is of no effect. They resolved and said it's of no effect. Nullification is used today. How do you think the state of Colorado, Washington, and California can have legalized marijuana? Medical marijuana, legalized marijuana. According to the DEA, the Drug Enforcement Agency, federal laws say marijuana is illegal. Now, I'm not for marijuana. I'm just saying the people of the state should decide whether it's right or wrong. And the Fed, what did they do when they legalized marijuana? They nullified federal drug laws. South Dakota, just a week ago, they put together a bill and passed it, signed by the governor, that if the county commission want it, if the school board in that county want it to happen, that they allowed the teachers in a school district, if the school district desires, to go in and have training and carry guns and bring a gun to school to protect the students. Now, wait a minute. That violates let me think of the name of the rule. Federal School Gun-Free Zone. 1990, 1995, that's a federal law. They're breaking a federal law when you take a gun anywhere near school. But the state said, no, we want to protect our kids. We're nullifying your law. We're nullifying your law. In the state of Tennessee, Brian Kelsey, you'll see Brian Kelsey here in just a minute. Now, 2 years ago, this man signed on to and voted for the Tennessee Freedom of Firearms Act, which states if a gun is made in Tennessee and used in Tennessee, it's no longer under federal guidelines. Wait a minute. Does the BATF have any of that in there? No, Bureau of Alcohol, Tobacco, and Firearms, they say that all guns are under our control. But Brian Kelsey himself 2 years ago said that if the gun is made in Tennessee and used in Tennessee, it's no longer under federal guidelines. What they do, they nullified that law. They nullified. Now, see, this Senate Bill 0250 by May Beavers, the former head, May Beavers, the lady that brought this bill in, until Ron Ramsey booted her out, she sat where Brian Kelsey sits. And this law would have passed had it not been for Mr. Ramsey. This law would have passed had it not been for Mr. Ramsey, because he booted May out. May brought this, all that she did is say, now, it's not just the guns made in Tennessee, it's the guns that are owned in Tennessee. Any gun owned in Tennessee and used in Tennessee is no longer under federal guidelines. And you listen to what Mr. Kelsey says. He comes, you can't do that. We're going to be like South Carolina, seceding from the Union. Nonsense. Nonsense. Why did they deny the Tennessee citizens their uninfringed right to bear arms with the expanded protection of Senate Bill 0250? All I left is question marks. What can we do? Any person comes up here wanting us to elect him or her to represent us in Nashville should be required to say publicly, if the federal law violates the Constitution, we will nullify it. That's what we have to demand that. We have to demand that.
All right, we're going to get set up and watch that judiciary meeting. It's going to take about an hour to do all the fine stuff. We can't hardly cut it down much more because it's that way. I just got a little note from the lovely one. Said, anybody ever hear of Rand Paul? He's going to be in Nashville on the 20th. We have a table. We have 3 seats still available. It's going to be it's a Saturday around dinner time. All right, we had 3 seats, and they were $50 a crack, and the lovely obviously made her first mistake of her life. You know what I'm trying to tell you? It never happens. I can't believe this. But pay attention to this, and after this is over, we'll have a little discussion about some of the people and some of the things that were said and how out of touch and how far into this we are.
And this particular bill does a number of other things in addition to that. And with that, Senator Beavers, you're recognized to describe the bill again.
Thank you, Mr. Chairman. We have 2 witnesses today. We have Mr. Mahary from the 10th Amendment Center. If he would come to the front, he has some testimony.
Without objection, we'll go into recess to hear from Mr. Mahary. Which, if you would, please have a seat at one of the chairs here. Make sure your green light is on, and state your name and title for the record, please. And we've got a total of 5 minutes to be. Is this to be divided, Senator Beavers, among anyone? Or is it just
Yes,
Mr.
we
Mahary?
have one more witness.
Okay, to
after
be
this.
divided between yourself and one other witness. Thank you.
So I only, there, make sure I'm on. So I only have I have 2.5 minutes, is that what we're saying?
However you like to divide up the 5 minutes. Yes, those are our
Mr.
committee rules. Thank you.
Mr. Chairman, I think you told me yesterday they would have 5 minutes each.
I'm sorry, Senator Beavers. Our committee rules are 5 total minutes among all presenters on a side. Those are our rules that we announced at the beginning of the committee this year in January. But we can't. They can take questions afterward. And I assure you, there will be questions. I assure you. Senator Bell, you. Yes.
Mr. Chairman, those are the clearly stated committee rules that you stated at the beginning of the year. There does seem to be, and I didn't know this until she just said it, a misunderstanding that she thought that you told her yesterday that the witnesses could have 5 minutes apiece. I'm going to make a motion that we suspend the rules in this case because of a misunderstanding. I would not have made that motion if there had not been a misunderstanding between yourself and the sponsor, at least on her part. At least on her part. I'm going to make a motion that we suspend the rules on this for this one time of testimony, that each of the presenters have 5 minutes apiece.
And there's a motion. There is a motion and a second on that. Is there any objection to that? Seeing none.
Can I have a quick
Senator Green,
comment
you're
on the
recognized.
motion that's made? Thank you, Mr. Chairman. As I understand it, this is the bill we're discussing for the rest of this special called session. Is that correct?
I imagine so, yes. I think we have 30.
We have 30 minutes.
We have 31 minutes, yes.
Okay, just wanted to.
Okay, without objection, that is so ordered, and you're allowed 5 minutes, Mr. Mahary.
Okay, I appreciate that. Thank you very much. My name is Michael Mahary. I'm the National Communications Director for the 10th Amendment Center, and I'm very honored to be here with you guys today. I'm going to address the Attorney General's opinion on this particular bill. As you probably know, in the opinion of Attorney General Robert Cooper, SB 250 violates the Supremacy Clause of the Constitution. And I've read his opinion, and his basic reasoning is very solid. Nevertheless, he came up with the wrong answer. Now, I'm sure you guys all remember working those long quadratic equations back when you were in high school algebra class, and you know that you can work all of the steps absolutely correctly, but if you do an addition or subtraction error in your very first step, you're going to come out with the wrong answer. Why? Because you've worked the problem working from the wrong premise. Cooper spends the bulk of his opinion correctly arguing that constitutional federal law trumps state law where it conflicts. Quite frankly, that was a waste of time. Nobody disputes that. The problem is that he incorrectly assumes that every federal act is constitutional law, and he builds his opinion on this fallacious premise. Fact: only laws made in pursuance of the Constitution are truly supreme. All of the Founding Fathers agreed, and I mean all of them, that any federal act that violates the Constitution is no law at all. Hamilton summed it up in Federalist 78. He said, every act of delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution can be valid. Cooper apparently wants the people of Tennessee to believe that the following federal acts mentioned in Section 5B of SB 250 are constitutional and therefore supreme: a ban on firearms, tracking of ammunition, federal taxes on firearms accessories, among other things. Where exactly does the Constitution delegate the federal government power to regulate firearms? It doesn't. Now, some will argue that there's some regulatory authority under the Commerce Clause. But we have the Second Amendment. And the Second Amendment puts further restrictions on the federal government. And we have to keep note of the most important phrase in the Second Amendment: shall not be infringed. Infringed means to interfere with. That leaves no wiggle room. Now, Cooper mentions the possible unconstitutionality of these acts almost as an afterthought. He writes near the end of his opinion, while the bills themselves declare that certain federal firearms regulations are unconstitutional, the responsibility for that determination rests with the judiciary, not a state legislature. Now, the Attorney General rests his argument on the Marbury versus Madison case, and I know we've talked about that in this committee earlier. But Cooper is misconstruing the Marshall ruling. Chief Justice Marshall was merely asserting that the court can, in fact, nullify an act of Congress by ruling it unconstitutional. Nowhere does Marshall assert that the court has exclusive authority to rule on constitutionality. In fact, quite the opposite. He wrote this: "The particular phraseology of the Constitution confirms and strengthens the principle that a law repugnant to the Constitution is void, and the courts, as well as other departments, are bound by that instrument." Now, the Attorney General also cites Cooper v. Aaron to assert the supremacy of the federal judiciary and that its rulings cannot be challenged. That case also rests on this same bastardized interpretation of Marbury. Such a notion obliterates the constitutional system, making the court the de facto sovereign. I shouldn't have to point out the absurdity of the court making itself supreme. It's like King Arthur claiming supreme executive authority because, in the words of Dennis and Monty Python and the Holy Grail, some watery tart threw a sword at him. Ronald Reagan, Attorney General Edwin Meese, said this about the Cooper decision. He said, "The logic of Cooper versus Aaron is at war with the Constitution, at war with the very meaning of the rule of law." We need look no farther than the Dred Scott case, which was brought up just a few minutes ago, which denied even free black citizenship and went on to proclaim black people as inferior, to see the inherent flaw in this idea of judicial supremacy. Do you really accept that the Dred Scott was legitimately the law of the land even for 1 minute? Abraham Lincoln certainly did not. In response to the ruling, he said this: "If the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal." Fact, the Attorney General tells us that only the federal court can determine constitutionality. Fact, Ronald Reagan, Attorney General Edwin Meese, Abraham Lincoln, James Madison, Thomas Jefferson all disagreed. Jefferson said this, and I think what we need to do here while we're considering this bill is to try to unravel his logic. He said, "The states are not united in the principle of unlimited submission to their federal government, and the government created by this compact, the Constitution, was not made the exclusive or final judge of the extent of powers delegated to itself. Simply put, the people of the states delegated the federal government its power in the first place. As Madison said, the states then, being parties to the constitutional compact, in their sovereign capacity, it follows of necessity that there can be no tribunal above their authority to decide in the last resort whether the compact, the Constitution, made by them is violated, and consequently, that as parties to it, they must themselves decide in the last resort such questions as may be the sufficient magnitude to require their interposition." Thank you very much.
Thank you. And why don't you just go ahead and stay here, if you don't mind, maybe scoot down a chair. Or actually, you're fine there. And then we'll take our second speaker can come sit beside you as well.
Should I turn this off?
Yes. Just press it one more time. And again, thank you very much for being with us today for this very important issue on constitutional issues, and we appreciate your words. We've got 5 minutes. If you would, please make sure your green light is on, and then state your name and title for the record. Thank you.
It is on. My name is Publius Hulda. I'm a retired litigation attorney, and I write on the original intent of the Constitution using the Federalist Papers. I do not go by Supreme Court opinions because for 200 years, the Supreme Court has been ignoring the Federalist Papers and the Constitution our framers given, and they have gone off on tangents of their own which have nothing to do with the Constitution. The Attorney General's opinion begs the question. He states that states can't nullify acts of the federal government which are authorized by the Constitution, but then he completely fails to cite article, section, and verse, clause, where the Constitution delegates to Congress authority to restrict our arms. When we ratified the Constitution, we created the federal government. We listed, enumerated every power we granted to our creature, the federal government. Article 1, Section 8, Clauses 1 through 16 lists most of the powers we delegated to Congress for the government for the country at large. We didn't put on our list that our creature could restrict our arms. We didn't delegate this power to Congress because our framers wanted the American people to be heavily armed. Alexander Hamilton and James Madison write about this in the Federalist Papers. In Federalist Paper number 46, James Madison writes, "Why the American people are armed. It is so we can defend ourselves, our communities, and our states from the federal government in the event it becomes tyrannical and oversteps the constitutional limits on its powers." In Article 1, Section 8, Clause 16, pursuant to that, Congress passed the Militia Act of 1792, where they required every able-bodied male citizen between the ages of 18 and 46, except for federal officers and employees, to buy a rifle, ammunition, and report to their local militia for training. Pursuant to Article 1, Section 8, Clause 11, Congress is authorized to issue letters of marque and reprisal. This is what authorizes private warships to make war on our enemies. These were the privateers who fired on British ships during the War of 1812. Our framers contemplated a people who were heavily armed. That is why we never delegated to our creature authority to restrict our arms in any fashion whatsoever. And when the federal government attempts to do so, they are usurping powers which they do not possess. The Attorney General goes by court opinions, not the Constitution. There is a vast gulf between the two. We have 200 years of Supreme Court opinions, and Mr. Chairman very kindly shared some of these 200 years of Supreme Court opinions, which have nothing to do with the Constitution. Charles Evans Hughes said over 100 years ago, "The Constitution means what the judges say it means." That has been the prevailing dogma ever since, and generations of lawyers have been indoctrinated with this lie. That is why we no longer have a federal government which is held down by the chains of the Constitution. What we have is rule by five judges on the Supreme Court who claim the power to do whatever they want to us and our country. So today we have two opposites, what the Constitution says and what the Supreme Court says. Well, your oath of office requires you to obey the Constitution, not the Supreme Court. The Supreme Court is merely a creature of this Constitution and is completely subject to its terms. My third point, the AG asserts that the that the Supreme Court is the exclusive and final authority on the extent of the powers of the federal government. But our framers knew that Supreme Court judges were as likely as anybody else to be corrupt, usurp powers, and act lawlessly. So Congress, the President, and the states all have checks on the Supreme Court. Hamilton shows in Federalist number 81 that Congress's check on lawless federal judges is to impeach them and remove them from office. The President has his oath of office as a check on the Supreme Court. The President's oath is to preserve, protect, and defend the Constitution. It is not to obey the Supreme Court. The Supreme Court was not set up in our Constitution as the superior branch of the federal government. And then there's no need for me to Madison says in his report on the Virginia resolutions that it is a plain principle founded in common sense that the states, as the sovereign parties to the Constitution, are the final authority on whether the federal government has violated the Constitution, and that the states may check all three branches of the federal government, not just, they may check the judiciary, the executive, and the legislative branches by nullifying their acts. If the judicial branch connives with other branches in usurping powers, our Constitution will be destroyed if we do not stop them. This is what James Madison said in his notes on nullification, in his report on the Virginia resolution. I'm sorry I didn't have time to finish. I hope that during questions, someone will ask me about the so-called nullification crisis of 1832.
Thank you very much for your comments, and we appreciate your staying here for questions. Ms. Holda, I think you have correctly pointed out that ultimately this bill is not about Second Amendment rights. If it were about the Second Amendment rights, we'd have the NRA down here asking us to support this bill.
It's about enumerated
this bill
powers.
is about constitutionality and who decides constitutionality.
Well, first
So
it's about...
in your opinion, excuse me, ma'am.
Yeah.
Sorry, thank you.
Sorry.
In your opinion, who decides constitutionality?
Okay, first, I do not have any opinions. All I do is channel our framers, the Federalist Papers and other original source writings. Our framers all said, James Madison, Thomas Jefferson, Alexander Hamilton, among others, said that in the last resort, the states are the final authority. The federal government is merely the creature of the states. The states, as sovereign members of the Federation, retain the ultimate authority to decide.
Okay, so the states have the ultimate authority to decide issues of constitutionality over the federal judiciary, federal Congress, and federal.
Right. That is what James Madison, Alexander Hamilton, and Thomas Jefferson
Well, how do you
said.
square that with Federalist 78, in which Hamilton said, by a limited constitution, I understand one which contains certain specified exceptions to the legislative authority, such, for instance, as that it shall pass no bills of attainder, no ex post facto laws, and like. Limitations of this kind can be preserved in practice no other way than through the medium of courts of justice, whose duty it must be, to declare all acts contrary to the manifest tenor of the Constitution void. All the reservations of particular rights or privileges would amount, without this, all those reservations of particular rights or privileges would amount to nothing.
I was hoping you'd ask me a hard question, Mr. Chairman. It is in the first resort the Supreme Court may pronounce on the constitutionality or unconstitutionality of acts, but in the final resort, the states have this power. And if you look at the next paragraph just after the one you just read, you will see where Hamilton says that the states, that the people are the ultimate authority.
Do you
Just in the paragraph just after the one you read.
Did you agree with the opinion of the Anti-Federalists?
Again, I don't have any opinions. All I do is say what our framers said. This is not ever properly a matter of personal opinion. But what did our framers say?
So I don't know what they said about this.
Well, I'm telling you what they said about
the Anti-Federalists.
I've told you what our framers said about nullification,
Well,
and in my latest
how about-
paper...
Excuse me, let me ask it in a different way. The Anti-Federalists, Robert Yates, said the judges under this Constitution will control the legislature, for the Supreme Court are authorized in the last resort, to determine what is the extent of the powers of the Congress. They are to give the Constitution an explanation, and there's no power above them, to set aside their judgment. That was, of course, written in protest to the Constitution and against its passage, but nonetheless, it was actually giving the sentiments that had been laid forth by the Federalists in the Federalist Papers that you
Right.
read.
The Federalist Papers were written in part in response to the Anti-Federalists to answer their objections, and many of the Federalist Papers address what they say are spurious objections. So that is a spurious objection. Of course, our Constitution doesn't delegate supreme power. It doesn't invest the Supreme Court with godlike status.
And do you believe that Madison, in your testimony, did Madison believe in the idea that states could nullify federal laws?
Madison has written 2 definitive works on this. His report to the Virginia legislature in 1799 and 1800, and then his notes on nullification written in 1834. I have hyperlinks to these original source works in the last paper on my website. I urge everybody to read these original source works by Madison for themselves. Madison is the one who said that ultimately the states have the right to determine the constitutionality of acts of all three branches of the federal government.
He also said in that same report to the Virginia State House of Delegates, the declarations in such cases are expressions of opinion, speaking of course, the Virginia resolution that he had drafted himself, which had said that the Alien and Sedition Acts were unconstitutional. He's speaking about his own writings. He said those are expressions of opinion, unaccompanied with any other effect than what they may produce on opinion by exciting reflection. Expositions of the judiciary, on the other hand, are carried into immediate effect by force. The former, speaking about the Virginia resolution of the state, may lead to a change in the legislative expression of the general will. So that hopefully they could change the opinions of Congress and the expressions of the opinions through congressional law. However, he said possibly even to a change in the opinion of the judiciary. The latter, speaking of the judicial decisions themselves, the latter enforces the general will. That's exactly what he said in that report.
Okay. You are reading from Madison's report on the Virginia resolutions written in 1799-1800. Are you reading his discussion of the 7th and 8th resolutions? Are you? Is that a yes? Okay. In the 7th and 8th resolutions, all Madison was talking about was that the states have the right to get together and discuss this and object. That was not the meat of it. The meat of what he said is in Madison's discussion under the 3rd resolution, and that is the one which I quote at length in my paper, James Madison Rebukes Nullification Deniers. So you're reading from a point which isn't relevant. The main discussion is under resolution number 3.
When he begins talking about that, it does begin to read as if he's talking about he's favoring the ideas of states having power until you get to his conclusion, in which case he says, no, these are actually just expressions of opinion, and it's the
Right,
court's decision which are enforced through effect.
No, he's
We
talking
agree
about how the
disagree on
states
that one.
can get, it isn't a matter of personal opinion, it's fact.
What question did the Civil War answer?
The question it answered was whoever has the most power wins.
And who had the most power?
Well, I am not an expert on military strategy.
Who won?
Bad guys.
Who won?
That doesn't answer anything about whether or not states can nullify lawless usurpations of power by the federal government.
So the Civil War did not answer any question.
May I address this? Are you suggesting that
sorry.
if I'm sorry.
I'm sorry. I've got one last question for Ms. Holda, and then we'll get to you. Yes.
Well, I hope someone will ask me about nullification crisis.
Yes. And so the Civil War did not answer any questions.
Are you suggesting that because the North won, that the rest of us, that all of the country for the rest of our lives must submit to everything the federal government does?
Can you point to one shred of evidence post-1865 that supports the idea that nullification is legal?
This is the Constitution that was ratified. It is not something which changes with the whims of judges. That is the complaint I have, that for 200 years we have this body of constitutional precedent which has been built up, which has nothing to do with the Constitution.
Okay, thank you, Ms. Holden. Senator Overby and then Senator Cantfield.
Well, thank you, Mr. Chairman. I really didn't catch the witness's name.
Publius Hulda. When the Federalist Papers were first published in newspapers, even though they were written by Hamilton, Madison and Jay. They were published under the name Publius. And Huldah, of course, is the Old Testament prophet at 2 Kings 22. The book of the law had been lost, but then it was found when the renovations were being made to the temple. And King Josiah said, well, take it to Huldah and see what she says. And she said, this is the law.
So is that that's an assumed name?
That is my nom de guerre, my pen name.
What is your name?
You know, you make me out to be a fascinating person. I'm just a little old lady who was puttering around in her garden studying biblical Greek until 4 years ago when I saw what trouble we were in, so I got my copy of the Federalist Papers, dusted it off, and started writing about the original intent of the Constitution. Nothing is about me. It's about our Constitution. It's about our country. So let us stick to what's important, not about personalities, because they are not important personalities. Our country is.
I would agree with you.
Thank you, sir.
But this is not about, you're right, this is not about personality. But, Mr. Chairman, every witness that we have who has testified since I've been in this General Assembly has identified themselves and who they are and where they, from whence they speak. And that was simply my question, to get it on the record, as every other witness has done. Thank you for the opportunity to ask, Mr. Chairman.
We'll hear from the sponsor and then Senator Campfield.
I just wanted to say that the chairman and I had an understanding about all of that, so.
Senator Campfield.
Thank you. Either of the witnesses, can you tell me, did the Civil War itself end slavery? Or did the Constitutional Amendment end slavery?
Technically, it would be the Constitutional Amendment, the 13th Amendment, because the Constitution provided for it until the 13th Amendment. That was what fixed the defect.
So it wasn't the war itself did not fix it. It was actually the changes to the Constitution brought by the people, brought by the states, that actually changed it. Is that correct?
That is correct, sir.
Thank you. I have some other questions, but I have a question. Can you tell me a little bit more about the case of 1832 that you were referencing earlier?
Yes. Thank you, sir. My favorite question. In the 1820s, South Carolina was an agricultural state. She produced cotton. She bought her manufactured goods from England. England bought Southern cotton. Now, there were infant industries in the Northeast who were manufacturing some of the same goods that England produced, but the domestic goods were more expensive than the English imports, so they couldn't compete. So in 1828, Congress passed the Tariff Act of 1828, which imposed a high tariff on the English imports. This made the goods too expensive for the southern states to buy, so they stopped buying them. English retaliated by stopped buying southern cotton, and this greatly weakened the southern economy. South Carolina attempted to nullify this. She developed a peculiar doctrine of nullification, which said that any state could nullify any federal law, and the nullification would be presumed to be valid unless 3/4 of the states in a convention said that the nullification was not valid. Now, James Madison opposed South Carolina's doctrine of nullification, and this is why. Article 1, Section 8, Clause 1 specifically delegates to Congress authority to impose tariffs, and further, it requires that the tariff be uniform in all the states. So we couldn't have a situation where South Carolina was paying no tariff, but the other states were paying the tariff. So South Carolina tried to nullify a constitutional law. That was the determining factor in this, that the Tariff Act of 1828 was fully constitutional. So in 1834, James Madison wrote lengthy notes on nullification, and he pointed out, one, the Tariff Act is constitutional. States cannot nullify a constitutional law. 1/4 of the states don't have the right to dictate to 3/4 of the state on matters which are in the delegated powers of the federal government. And
Just
finally,
hold on. I'm so sorry to interrupt you, but we only go until 1 o'clock. So if you could just keep your answers as short as possible, that would very much help us out. We have Senator
I
Stevens.
still have a question.
and
I have
then-
2 more questions before I'm done with her.
Okay, very quickly. Because
Okay.
we got Senator Stevens, Senator Green, and then we'll be done.
Okay, very briefly, what do you think was the purpose of the 10th Amendment? And we talked about what the Constitution has been, how the Constitution has been changed. Has there been any constitutional amendments that removed the 10th Amendment that I missed somewhere?
no.
Okay.
No.
What is the
Senator
purpose for the
Canfield,
10th
last
Amendment?
question.
Just to make it clear that the Constitution we ratified, the Constitution everybody voted for, is one of limited enumerated delegated powers. Depending on how you count, only 21 powers were delegated to Congress. None of them is the right to restrict our arms. The purpose of the amendments was just to reassure some of the states who were nervous about the federal government having too much power. And the 10th Amendment says, you know, we really mean it where we enumerate the powers in here. We really mean that that's all they have and that the federal government has everything else. James Madison discusses this the best in Federalist number 45 at the fifth or the 9th paragraph.
Okay.
Thank you very much.
Senator Stevens.
Yes, Mr. Chairman, thank you. The examples of overturned nullification mentioned by both yourself and the AG, at least as I've looked at them, all seem to be examples of states attempting to nullify federal law that was in fact constitutional. Are there any examples of overturned nullification efforts where the federal law was unconstitutional? And that's a question to either the witnesses or yourself, Mr. Chairman.
My problem is that we're getting into circular reasoning here. The witness stated that South Carolina nullified the act, but that the act was constitutional. Well, that's the whole question, is who gets to decide whether it's constitutional. And if the testimony is that the states get to decide it, then the state decided. So I think that ends the question, but I'll let the witness answer your question.
Well, sir, that's very easy. Article 1, Section 8, Clause 1 delegates to Congress authority to impose a tariff.
Obviously, it wasn't very easy for South Carolina. And the
No,
convention
South
that
Carolina
disagreed
said
with
you
on
can
that.
nullify
You've said that they have
constitutional
the final-
laws.
Excuse me, I'm sorry. And that they said that they have the final authority on that. But let me go back to Senator Green.
Yeah, Mr. Chairman, if I could, though, nowhere in our history has there been an attempt to nullify federal law that was unconstitutional. So we don't really have a record, right? And nowhere in the Constitution does it state otherwise that states can't, other than you would cite the Supremacy Clause.
I am not trying to dodge the question, but the question really is circular, because you're assuming that you personally have the ability to determine constitutionality. And what I'm asserting is that the Supreme Court, according to Madison, had the ultimate, no, not in Marbury versus Madison, according to Madison himself in the Federalist paper, I'm sorry, Hamilton in the Federalist Papers, Madison himself in his report to the Virginia House of Delegates, and then also Marshall in the Marbury versus Madison, they said the court did, and that's ultimately the question, is who has the ability to do it.
That is not correct,
Sorry,
sir.
I know we disagree on that, but Senator Green.
Yeah, if I could also state, I do want to bring up one Supreme Court case very quickly, if I could. It's a case called Reed versus Covert. In this case, Miss Covert was the wife of a military soldier assigned to England, and while she was in England, she killed her husband. The United States had a treaty which, according to the Supremacy Clause, essentially makes it equal to the law of the land. And that treaty should, per the Supremacy Clause, have had priority. However, the court's opinion stated that the Fifth Amendment and the Sixth Amendment essentially overrode the Supremacy Clause. They limited the Supremacy Clause because they were limits as a part of the Bill of Rights on the federal government. So it would seem intuitive then that so would the Second Amendment.
And with all due respect, that is a misunderstanding of the Supremacy Clause. The Supremacy Clause says that the Constitution is the supreme law of the land, and that acts of Congress, and including treaties that are ratified by the Senate, that are entered into in pursuance of the Constitution, are also valid federal law. However, they cannot be trumped by the Constitution, and that was the issue in this particular case. The court ruled that the Constitution itself, and in this instance the Fifth Amendment, is what had prohibited that particular treaty from being
Supreme,
from being enacted in pursuance of the Constitution itself, and that was the issue in that case.
Right, and I guess I misspoke. The point I was trying to make is that from a pure reading of the Supremacy Clause, and it does say in pursuance, I understand that. But the Bill of Rights and those amendments do, as they are part of the Constitution, make any effort to usurp them inappropriate and unconstitutional. So any effort with the Second Amendment, whether it be a state law or a federal law, that is unconstitutional according to those amendments, I think we have a right to stand opposed to that.
Senator Stevens.
Thank you, Mr. Chairman, and thank you for your testimony today.
Yes, sir.
When you made the statement that the adoption and the ultimate power lies in the states, or something to that effect,
yes,
correct? Sir. When you say that in reference to the founders as well, didn't they put that in the Constitution in Article 5 of Section 3?
Ms. Hulda.
Don't the states act upon the Constitution by ratifying amendments to the Constitution?
That's one way, but that does not preclude, according to James Madison, Thomas Jefferson, and Alexander Hamilton, nullification.
But the Federalist Papers weren't adopted by the states, correct?
No, sir, but they were considered as the most authoritative commentary on the original intent of the Constitution until Charles Evans Hughes said, the Constitution means what we say it means.
Well, but the Constitution was adopted by us.
Right.
People.
Right.
Through the amendment process, correct?
Well, through ratification.
Right, but not the Federalist Papers.
No, but the Federalist Papers were considered authoritative on the genuine meaning. It's like advertising. These Federalist Papers were used to explain the proposed Constitution to the people and induce them to ratify it. So it's like advertising. This is what we were promised.
So you're asserting that outside of Article 5, or outside of Article 3, Section 5, the states can act to amend or to change the Constitution outside of Article 3, Section 5?
No, sir. What I'm saying is that when the federal government makes a clearly usurpacious law, such as restricting our firearms, it is the duty of the states, imposed really by their oaths of office, to support the Constitution and to defend the Constitution from the attacks on it by the federal government. And that is what our framers said.
But didn't we enact that the judicial branch would rule something constitutional or not? And then if we disagree, we the people disagree with that ruling, we can change the Constitution through the amendment process. Isn't that what we adopted?
No, sir, that is most manifestly not what we adopted. What we adopted was a Constitution where the Supreme Court is every bit as subject to the terms of the Constitution as the other two branches. We, the people, are the creators. The federal government, including the Supreme Court, are merely our creature. And the Supreme Court is completely subject to the terms. And our framers understood that Supreme Court judges might usurp powers. That's why Congress has the power to impeach and remove them for usurpations.
We're down to about
Thank
about
you.
two.
Thank you for
2
your
minutes.
testimony. Thank you, Mr.
Thank
Chairman.
you. Senator Gardenhire, last word.
I would love to hear the sponsor of this bill say some words.
If you would, please keep your seats here. Thank you. Yes. Senator Beavers, would you like?
Senator Bell put, I don't know if you want to recognize him first.
Senator Bell.
Mr. Chairman, I do have something I want to say, but, prior to the time we take a vote, do we plan on taking a vote today?
Yes, right now.
Okay, I want to, when we go back into session, my question or my statement is not to them, but when we go back into session, I'd like to be recognized.
We are back in the session. Senator Bell, you're recognized.
Thank you,
And
Mr.
thank you for
Chairman.
your testimony. I really, really do wish we had more time to explore these issues. I really do.
No, we do.
They're very interesting. Thank you for your testimony.
Mr. Chairman, I have truly been fascinated by the discussion going on for the last hour, I guess, 45 minutes to an hour. I feel like a lot of the discussion has been up in the clouds, and I don't mean that in a demeaning or derogative way. Just it's been a very intellectual, scholarly discussion on your part and the research that you've done, and on the part of the witnesses. I've got a couple things that I'd like to say before we vote, and I would like to make a statement directed at, and I'm in favor of this bill. I'm going to vote for this bill. But I do want to call out some of the people who have been, I think, saying some very unkind things about the chairman and other people who have legitimate problems with this bill. Political discourse has to be civil. It has to be. And I've received some of the emails, and I've been copied on some of the emails that I know the chairman has received. And political discourse has to be civil, even when we disagree. And Mr. Chairman, again, I wanted to point that out, and I thank you for your leadership on this committee. The chairman earlier referenced the opinion of Chief Justice Roberts in the case concerning the Affordable Care Act. And I found at least a couple of quotes from that opinion relevant to this discussion. Chief Justice Roberts quotes Chief Justice Marshall nearly 2 centuries ago when he says that the question respecting the extent of powers actually granted to the federal government is perpetually arising and will probably continue to arise as long as our system shall exist. We're here today with one of those questions. We have a question that arises, where does the power actually lay concerning the regulation of firearms? And there are different opinions on this committee. I agree with the sponsor and the intent of her bill that it should be with the states. I would also like to point out that the Supreme Court, as has been pointed out, has made numerous decisions over the years, and later Supreme Courts have overturned those decisions. I looked up just a few. Lochner versus New York was overturned by Adkins versus Children's Hospital. Adler versus Board of Education was overturned by Keysishan versus Board of Regents, University of New York. Pace versus Alabama was overturned by Loving versus Virginia. Austin versus Michigan State Chamber of Commerce was overturned by Citizens United versus the Federal Election Commission. Wolf versus Colorado was overturned by Mapp versus Ohio. Plessy versus Ferguson was overturned by Brown versus the Board of Education. I bring those out just to again reiterate the point that the Supreme Court is not perfect. The Supreme Court constantly, over the last 2 years, has overturned itself and corrected earlier decisions. Mr. Speaker, thank you.
Thank you. Thank you for your words. Senator Campfield, if everyone could remain brief. Thank you.
Thank you. I will. Seeing as there is testimony and questions still being out there, and as I believe Senator Beavers would like to bring amendments, I move we adjourn until next time.
That's a proper motion. Is there a second? There is a second. We'll do this on a voice vote. All those in favor signify by saying aye.
Aye.
All opposed, no. No. In the ayes of the chair, the motion fails.
I would ask for a roll call vote on.
Roll call vote on the motion to adjourn.
Senator Bell? Votes aye. Senator Campfield? Votes aye. Senator Finney? Votes no. Senator Ford? Senator Gardenhire? Votes aye. Senator Green? Votes aye. Senator Overby? Votes no. Senator Stevens? Votes no. Chairman Kelsey?
No. 4-4, the motion fails. Senator Green, you're recognized.
Yes, very quickly, I also wanted to echo what Senator Bell had said, that everyone in this discussion seems to have a very genuine heart to do the right thing, and everyone seems to be approaching it from an honest and sincere heart and desire to do the right thing. So I commend everyone in the discussion, everyone. And the stuff that has been in the emails in a derisive manner is just inappropriate. I do also want to state that several years ago in 1982 on the plane at West Point, I took the oath to defend the Constitution of the United States against all enemies, both foreign and domestic. I went to war to defend this nation and this Constitution, prepared to give my life for its defense. There are thousands of Americans through history who have given their life defending the Constitution. I believe that Senate Bill 250 defends the Constitution of the United States, and therefore I will be voting for it.
Thanks, Senator Green. Senator Finney.
Thank you, Mr. Chairman. There's a member of the administration here. I think the governor is going to be tasked with defending this law. If it should become law, he will be tasked with carving a budget that prosecutes people who violate this law. And for that reason, Mr. Chairman, I ask very briefly if Mr. Arnold can come forward and tell us if the administration has a position on this bill.
I appreciate the request, but at this time that we've moved out of recess and we've got to move forward on a vote on this. Out of due respect to our fellow colleagues here.
Well, Mr. Chairman, I would point out that the committee has been addressed by someone who refuses to give their name, who has no opinions by her own admission, and I'm asking for a few seconds for Mr. Arnold, who represents the governor, to come forward and tell us what their position on the bill is. I don't think that my request is unreasonable given what we've listened to over the last hour. The rest of us have indulged this committee.
If you've
been glad to hear all this, I think it's certainly reasonable to hear what the administration's position is.
Then if you would, please put that in the form of a motion.
I would make that motion that we
Is there a
take
second?
30 seconds.
There's a second. All in favor signify by saying aye. Aye. All opposed, no.
Mr. Chairman,
Yes, Madam.
I have an amendment that could affect their opinion. Could I have a chance to put the amendment on?
I asked if she speak a while ago. Okay.
We're going to have to go here in about 30 seconds. Could you give a yes, no, or neutral statement for the record, please? The motion did carry. Mr. Arnold. Yes,
Okay.
sir.
Sammy Arnold, Governor's Office. Thank you, Mr. Chairman. Senator Finney, the position of the administration is flagged for money because of the cost. We're not working against the bill, but the administration does have significant concerns about the constitutionality of it as it's written right now. And if the bill were to get to the governor's desk, I think there's a good chance that he's not going to sign it if those concerns remain. So,
Thank you very much for that. With that, we are back into session, and thank you. The question has been put. There's a second. All those in favor of the previous question signify by saying aye. Aye.
No.
Okay.
Mr. Chairman, I have
The
an
motion was
amendment
for the
that we filed
previous
with
question,
committee.
and that motion in the eyes of the chair failed. And so we are back on the bill, and Senator Beavers has an amendment. Is there a motion on her amendment? It's
I have an
moved by
amendment.
Senator Campfield and by Senator Green. We will take, this amendment is the one that reduces it from a felony to a misdemeanor. Is that correct?
That's right.
Okay, all those in favor of the amendment signify by saying aye.
Aye.
All opposed, no. No. We'll take a roll call vote on the amendment. Mr. Moore.
Senator Bell.
Point of order.
Point of order. On point of order, Senator Bell.
I need the drafting code on the amendment.
The drafting code is 3865. It changes it to a Class A misdemeanor from a Class B felony.
And takes the fiscal note off of it.
And takes the fiscal note off the bill. Mr. Marr, would you please call the roll?
Senator Bell. Votes aye. Senator Campfield. Votes aye. Senator Finney. Votes no. Senator Ford. Senator Gardenhire. Votes aye. Senator Green. Votes aye. Senator Overby. Abstains. Senator Stevens. Votes aye. Chairman Kelsey. Mr. Chairman, we have 5 ayes, 2 noes.
5 ayes, 2 noes. The motion carries. The amendment is on the bill. And I would also like to point out for the members that we do have a written letter signed by the Tennessee Bureau of Investigation, Tennessee Sheriff's Association, Tennessee Chiefs of Police, in which they say that these federal employees are our neighbors. They go to school with us. They attend our churches. In essence, they don't want to arrest them. And that's what this ultimately is about. This is a bill that says that our individual sheriff's deputies will be going out and using deadly force of the law of Tennessee to potentially shoot and kill federal authorities for enforcing U.S. Supreme Court decisions. And if
Mr.
states have the
Chairman?
ability to nullify that under the Chicago ruling, then they have the ability to nullify the Chicago McDonald case, and that would allow for a prohibition of handguns throughout the city of Chicago, because the state of Illinois could simply nullify that decision from 2010, that McDonald decision. And so that's not what this is ultimately about. It's not about Second Amendment rights, or the NRA would be down here. This is about who has the final say on constitutionality. Senator Beavers, to close.
Mr. Chairman, I would just like to say it's now reduced to a misdemeanor, which means they could simply issue a citation instead of arrest.
Okay, Mr. Marr, please take the roll on the bill as amended. And the motion is to
I have not heard
to calendar.
Motion to call the question.
The motion is to calendar. Mr. Marr.
Senator Bell.
Point of order. I'd like an opportunity to speak on the bill.
Senator Stevens, Senator Stevens, we have got to take a vote on this bill.
Point of order.
Point of order. Senator Campfield.
I did not hear a motion to call for the question. I did not hear a vote on the call for the question, and therefore I don't know if that's a proper motion to call for the question.
We are now 20 minutes
That does not change
into
the
Senator
rules.
Tracy's
That does not
committee
change
meeting
the rules
at
for a
this
committee
point.
meeting. If you wanted to roll it,
Senator Stevens has the last. Is anyone other than Senator Stevens want to speak? Senator Campfield and Senator Stevens. Senator Campfield, you've got the floor. Then Senator Stevens. Then we're taking a vote.
thank you. If you wanted to push, we could have rolled this on and continued our conversation. My question with point of order, I did not hear a call for the question, which would require a second and would be a motion that would be questioned before the whole committee. If you were going to make that motion, that's fine, but I think that's something that's taken of a vote. You do not automatically call for the question unless there's objection. You usually have to say something along the lines of call for the question. I did not hear that. If I missed it somewhere, I do wish to object. Thank you.
Okay. Now we're back for Senator Stevens to close without objection. So ordered. Senator Stevens. Senator Stevens.
I've spoken to my local sheriffs in 5 of the 6 counties I represent. I've spoken to the district attorney generals in my counties as well. Even with the bill as amended, it still places the burden on local law enforcement to arrest a federal officer if they're in the state of Tennessee to enforce a federal law, that is constitutional or not. Their job is not to determine the constitutionality of a bill. Their job is to enforce the law. They object to this bill because it places them in the unenviable position, from the Sheriff's Department standpoint, of arresting people that they go to work with every day to keep each and every one of us safe. In addition, the district attorney generals are officers of the courts, and they are also under the arm of the attorney general, who has opined that this law is unconstitutional. Therefore, if a district attorney general prosecutes someone under this act, they have lost their immunity from any prosecution or any action against them in a civil court of law, and they therefore place themselves personally liable for their actions. In 1880, in the case of Tennessee versus Davis, which the Attorney General referenced, a federal revenue officer came to the state of Tennessee to bust up a moonshining operation. In the course of making that arrest, there was gunfire and he shot and killed someone. He was arrested by the state of Tennessee. There's a federal statute on the books. It's 28 U.S.C. 1442, and it allows a federal officer who is in the course and scope of his employment, who's arrested, to remove his case to federal court. That is still good law. That case is still on the books, and that statute is still on the books. With that in mind, if we pass this law, we are absent the constitutionality of it. We are passing a futile act, because any officer, if anyone does get arrested under this act, they will immediately remove the case to federal court. They won't be tried in the state of Tennessee. They'll be tried in federal courts in Tennessee. And therefore, we have spent all of this time on an issue that will not resolve anything. That this is merely, in my opinion, a symbolic act. Now, I agree with the symbolism of the act, because we must protect our Second Amendment rights. But we must do so within the proper procedures that we've all passed and agreed to in our glorious Constitution. And for that matter, I will not be supporting the bill. Thank you, Mr. Chairman.
Thank you. Mr. Marr, please take the vote.
Senator Bell. Votes aye. Senator Campfield.
I object. I ask for a call of the clerk to see if a call for the question was ever made. And who seconded the motion?
Senator Campfield, the chairman has ruled that there was no one else who wanted to speak. The last two people who were, and I'm not going to get into an argument over this. The order was Senator Stevens to close, and now you are charged to vote aye, no, or abstain.
I would ask a call for the clerk to see if the question was called.
Aye, no, or abstain.
I object, but call.
Okay. Next member of the committee, please.
Senator Finney. No. Votes no. Senator Ford. Senator Gardenhire. Votes aye. Senator Green. Votes aye. Senator Overby. Votes no. Senator Stevens. Votes no. Chairman Kelsey.
No.
Mr. Chairman, we have 3 ayes, 4 noes, and 1 abstention.
3 ayes, 4 noes. The bill fails. Senator Campfield, how do you vote?
I voted yes, but objected to the motion.
The vote is 4 ayes, 4 noes. The bill stays in committee.
Mr. Chairman, could I say one more thing? I think that even though we didn't get the votes in committee today, it's still alive. But regardless of that, this has caused the best debate we've ever had on the Constitution. And so even if this bill never flies, it's something we need to continue so that we as legislators know what the Constitution entitles us to do, to know what our freedoms are in this country, because they're being taken away Very quickly.
Thank you, Senator Beavers, and I agree with you 100%. Senator Overby has moved to adjourn without objection, so ordered.
Well, that's the way it works in a constitutional republic. The sponsor, the person who put the bill forward was May Beaver. She used to head that committee. She was pulled off of that committee this year by Lieutenant Ron Ramsey because she was not a team player. Well, he's a team player. Mr. Kelsey is obviously a team player. He carried the water. He did the job. He killed that bill, and that was his job, to kill that bill, because we have two agendas at the state capitol. What you got to understand is the Republicans killed that bill. They are Republicans. They are the people that are supposed to be able to straighten this mess out on the state and national level. Good luck. That bill could have passed out of that committee if the lieutenant governor would have broke that tie. He was not in the building, and don't think for 1 second that he didn't have that bill whipped the day before and knew exactly what the vote was. And he was out of that building because he'd seen what happened to Deborah Maggart when she played the game, so he didn't have to vote. Now let's talk about Mr. Haslam not signing that bill. I'll tell you what he wouldn't have done. He wouldn't have vetoed it because the NRA would have scored him. So he wouldn't have vetoed it. It would have laid on his desk for 30 days and became law if it would have passed the full session. Without a defense of the Second Amendment, the rest of the Bill of Rights is useless. When the guns go, the rest of them are done. Now on the federal level, you have Republicans talking about increasing background checks, mandatory background checks. Don't fall for this gun show loophole thing. Every dealer at a gun show has to background check every gun he sells. The number one expense for running a gun show is running the phone lines into the building. The guy that they're talking about is the guy that's walking around with a gun on his shoulder, and somebody walks up and says, "Hey, you want to sell that thing?" He said, "Yeah, I might. Make me an offer." He can do that on a Walmart parking lot. He can do that in this building. He can do that anywhere. That's what they're really after. They want to check me from selling a gun to Mr. Chernock. They want us to go to the gun store and pay for a check on Mr. Chernock. He probably won't pass it, but check it. But what they're not telling you about that issue is, for that to be effective, you're going to have a mandatory register. Okay, they got to know where every gun is before they can run that. And when you have a mandatory register, ask Nazi Germany how it worked for them, the Australians, the Japanese. I don't know how England, I don't know how that's going to work out. Bob Corker won't make a stance on it. Of course. Now, what's Lamar say? Lamar says, "I stand for the Second Amendment." Well, guess what the difference between Lamar Alexander and Bob Corker is? Bob Corker just won his election. Lamar's up for one. If it would be the opposite, the stance would be the opposite. Lamar wouldn't give you a statement. These are Republicans. So it's a rough road to hoe, guys. I don't know. And that's the way they have been going down there the whole session. Republicans are killing them, one after another. There was only one Democrat in that committee meeting. One Democrat. Ophelia Ford was out. She heard her back. Ophelia Ford is a Democrat out of Memphis. But she'd have voted for it. She carries. She was a yes vote, I'm pretty sure. That's why Stacey Canfield, the other good one on that committee, wanted to roll that bill. They never got a legal motion to call the bill. They stepped on parliamentary procedure to have that vote. Why would a Republican do that? Because there's two sets of agenda at the session this year. There's the agenda of a half a dozen to 18 good hardcore conservatives. And then there's the agenda of three people driving the deal. Circled the wagons. The first thing you got to do is you got to slap a couple of them upside the head to show the rest of them it can happen. So you hammer May Beavers and Judd Matheny, and then you get the rest of them to carry water for you. So those three people's personal agendas standing in the way of the defense of the 10th Amendment in this state. And I don't know how we're going to fix it. I mean, they're under the impression there's nothing we can do about it. And I'll have to agree, continuing to do the same thing over and over and over again and expect a different result is a sign of insanity. So we need to have a conversation about what needs to happen. We need to pay a little bit better attention to what's going on. We need to hold these people highly accountable. Doug Overby, the one that questioned her on, but not anything she said, but on just who she is. He questioned that with the help of the Democrat. And who called on and who called for the governor's opinion? It's the Democrat. He probably just had lunch with him. They got a lot in common. So that's a hard one to swallow in a conservative state like this, that's who's running the show and how they're running it. There's a lot of work to do, guys. You need to take a serious thought on how you want to go about this, but it's not looking good for what it is. But we appreciate all the new guys. We've got a lot of new people here tonight, and we appreciate you. And we hope you come back. And we'll probably be looking into having a conversation maybe here with the young lady that testified at the committee. I believe we need to roll her in here and have a talk with her if she will bless us with her presence, and I think she will. You had to have been there in person and listened to that. She literally slapped the far out of him a couple times. I mean, she didn't have to look at a piece of paper. She has those papers memorized. And it's, Mr. Chernock. Yeah, it'll be, and if anybody wants to show this to their friends, if anybody has somebody who couldn't make it, these things are being put up on the website, and this guy right here is making that happen. This guy made this happen. So he needs to get a hand. Give him a hand, guys. What's up, Ronnie?
Maybe instead of just the lady coming down, we should have the speaker come down and have a conversation.
Right now, there's probably in 4 or 5 of the major newspapers in his area, there's been some right nasty articles run on him, basically just telling what it is, and the donations are rolling in to keep them coming into the paper. So he's catching fire pretty good for this. And I dropped one of our calendars off to him the other day that's on the Bill of Rights. And I just dropped it on the desk and told the guy, I said, hey, this is for Mr. Kelsey, but tell him we had these printed before we realized that the Civil War destroyed all that. So just look at today's Bill of Rights. The stuff at the top is just irrelevant. But we do need to have a little bit of a conversation about what Mr. Bell said about keeping things civil. And when you call these people, today was Floyd fit to be out. I made phone calls. She'll testify. I probably made phone calls for 3 solid hours. Just, I can do that 615-741. I mean, it's like pop, 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 pop. My phone will go out on those. You know what I mean? And I'll be there tomorrow at 8 o'clock in the morning, and it'll be war all over again. But what that guy was referring to, there was some right stiff emails that come out dealing with Mr. Kelsey. It would be Kelsey here and Obama here, and statements. We need to reserve that kind of thing until after this is over. I had a little opposition to that stuff going out before that thing was voted on. Now, after it got voted on, send them out. It's true. But until it did, we need to keep it fairly civil and be above the board. But with that said, it's probably okay now, but hey, we appreciate you guys. You're the guys that make this happen. But you guys need to take a serious thought about what you just seen right there. And when they try to tell you how conservative the state of Tennessee is, it could be much, much better. And there's 8 or 9 other states pursuing this same stuff. And they got watered down, but some of them are going to pass. So we need to not be following the pack. We need to be leading the pack in Tennessee. So we need to have a frank conversation about how we're going to get this done and make some changes in the way we're doing business, I believe. But we'll see about all that. Hey, thanks a lot. Oh, question. This will all be on our website, Humphrey County Tea Party, and there will be a thing over there that says meetings. I think you can go get all the meetings. Are they still up? All the meetings we've had since we started this are on the website. You can go to them and hit them, and it's really good.
Go to the website and click on archives.
Click on archives and then hit the month that you want to see the meetings. You can see every meeting we've had since we started this. Hey, thanks a lot. Appreciate you guys.